SDPB helps shape South Dakota's future by educating, informing, and inspiring the next generation of thinkers, leaders, and creators. SDPB. Good, useful, and full of wonder. SDPB serves South Dakota through an interconnected communication system that is on 24/7, 365. The first place for Amber Alerts, public safety announcements, and EAS messages. SDPB keeps public servants and citizens informed. Good, useful, and full of wonder. SDPB.
You bet. Call the House Judiciary into order. Mr. Secretary, please take the roll.
Representative Mortensen.
He's in a court trial right now.
Excused. Reich.
Here.
Wahlberg.
Here.
Roby.
Here.
Fitzgerald.
Here.
Reimer.
Here.
Whitman.
Here.
Massey.
Here.
Cole.
Here.
Poirier.
Here.
Hunt.
Yeah, here.
Hughes.
Here.
Stevens.
Here.
We have a quorum.
Thank you very much. We have a motion by Representative Whitman and a second by Representative Hunt to approve the minutes. All in favor, say aye.
Aye.
Opposed, nay. Minutes are hereby approved. We have our pages come forward. We have them in here. Why don't you come forward, introduce yourselves, tell us where you're from.
My name is Veronica Thomas, and I'm from Harrisburg.
Thank you for coming.
My name is Derek Thompson, and I'm from Hill City.
Great. Thank you guys for both coming, and appreciate you taking your time. And it's very helpful to us to have you here today. What we're going to do today is, first of all, I've been asked by Representative Randolph to table House Bill 1322. Do we have a motion to do that?
Yes, Mr. Chair. Yeah, I moved to table House Bill 1322 at the request of the prime sponsor.
And there is a second by Representative Hunt. This is non-debatable matter. Mr. Secretary, please call the roll.
Oh,
Representative Mortensen, excused. Reich.
Aye.
Wahlberg.
Aye.
Roby.
Aye.
Fitzgerald.
Here.
Reimer.
Aye.
Sorry.
Whitman.
Here. Aye.
Massey.
Aye.
Cole.
Aye.
Thank you. Fourier.
Aye.
Hunt.
aye.
Hughes.
Aye.
Stevens.
Aye.
12 yeas, 0 nay, 1 excused.
Our committee will be meeting later on to know how to vote. So what we're going to do today, because this is our last day, we have to have all of our bills across. We'll be limiting the testimony to 12 minutes. I will give you the 1 minute time. I've talked to the sponsors so that they're going to control who comes and speaks, but when the 12 minutes are up, we're going to go, and I appreciate your cooperation with that, everybody, today. And I'm sorry that we have a lot of people who have signed up online to talk, but we're going to let the sponsors kind of control that. But I do really appreciate it, and I know the committee does too, knowing that there are people who are listening and want to contribute. Whether you're a proponent or opponent of the bill, it's very appreciative that you are willing to participate in our process. So what we're going to start with today is House Bill 1067, an act to provide a rebuttable presumption in favor of joint physical custody of a minor child. Good morning, Representative.
Thank you, Mr. Chair. This is Bobby Andera, Representative, District 10. Thank you so much for taking the time and hearing me out on HB 1067. Today I present to you HB 1067, an act to provide a rebuttable presumption in favor of joint physical custody of a minor child. Specifically, there is a rebuttable presumption that joint physical custody is in the best interest of a minor child. This presumption may be rebutted by evidence showing that joint physical custody is not in the best interest of the child based on the factors set forth in Section 25(4)(a)(24). In addition, the bill also defines joint physical custody, which means a division of time with the child that is approximately and reasonably equal for each parent as agreed to by each parent or as ordered by the court. You may be wondering, why is a single woman with no kids presenting a bill regarding child custody? Well, I consider myself an ambassador of sorts for my close friends, my family, and my district. Specifically, a community that I hold dear to my heart, that I also feel are underrepresented in the environment that is divorce and child custody. A community of people who still feel they are being targeted or shamed due to their orientation during or after divorce. This community is part of my district, my family, and my closest friends. Research briefing was released on May 22nd, 2024, utilizing a plethora of reputable resource material on parental sexual orientation and child custody outcomes. The subject of this research was the analysis of social science data, judicial trends, South Dakota legal context regarding LGBTQ parents in family court. They stated that legal scholars note that trial courts often use the inherent discretion of the best interest standard to reintroduce bias. In practice, speculative harms, such as potential social stigma or role modeling, are often used to justify decisions that favor heterosexual parents. Gendered bias and stereotypes research by Clifford Roski and others highlights that gay fathers face distinct gendered stereotypes in custody disputes. Gay fathers are disproportionately subjected to unfounded stereotypes regarding HIV status and child molestation, particularly when the children involved are boys. Appellate analysis suggests that male judges may be more likely than female judges to apply these stereotypes in their reasoning. There is also a coming out risk. Coming out at the conclusion of a heterosexual partnership often triggers an adversarial response where the father's orientation becomes a central point of litigation, regardless of his prior parenting history. In case law, back in 1992, Chacon versus Chacon out of the state of South Dakota is the primary precedent in this area. It reflects historical judicial concerns. In this case, the trial court awarded custody to the father and restricted the lesbian mother's visitation based on her lifestyle. While South Dakota Supreme Court adjusted the order on appeal, the case remains a significant example of how sexual orientation can be used to justify special visitation restrictions under the best interest standard. So what is our current statutory framework? The best interest standard, South Dakota SDCL 25-4A-24, requires custody decisions to be based on the child's best interest, but does not explicitly prohibit the consideration of sexual orientation. Joint custody. The state requires courts to consider joint physical custody if requested, focusing on the parent's ability to cooperate and support the child's relationship with the other parent. Protection gaps. While there is no explicit statutory basis to penalize gay parents, there is also no explicit protection preventing judge from viewing sexual orientation as a factor affecting stability or morality. Anytime we have judicial discretion, there is an opportunity for bias. Let's work together to create a level playing field at the outset and work from there for all South Dakotan parents, regardless of race, gender, background, or creed. Thank you.
Thank you, Representative. Who would you like to have speak next? You have a little less than 8 minutes left. Did you have Mr. O'Connor? Yes, I have a list here. You're going to follow that? Yeah, thank you very much. Mr. O'Connor, you have a little less than 7 minutes now.
Good morning, Mr. Chairman and committee members. My name is Shane O'Connor. I'm from Burbank, South Dakota. Family is the most important influence in a child's life. I'm a father who has experienced firsthand how our current system is failing our kids. I faced an expensive, emotionally devastating fight simply for the equal opportunity to raise my own children. This isn't just my story. It's happening to countless families across South Dakota right now. Our current system forces one parent into a secondary role, creating unnecessary conflict and robbing children of the love, stability, and nurturing environment they deserve from both parents. House Bill 1067 promotes shared parenting, maintaining a consistent presence in both homes, providing children with a sense of security and stability. Empirical data shows that children raised in 50-50 custody arrangements have better emotional and behavioral outcomes compared to those in sole custody situations. This balanced approach not only supports a healthy development for our children, but also prevents families from diverting critical resources, such as funds earmarked for their children's college savings, into prolonged legal conflicts. It's time for South Dakota to join the other 31 states with similar legislation and proposal for a more equitable, child-centered system. I urge you to support House Bill 1067 so that our laws reflect what's best for our children and ensure that both parents can contribute equally to their upbringing. Thank you.
Thank you very much. The next one we have is Mika Pence. Is online. Thank you. Ms. Pence, can you hear us okay?
Yes, I can hear you. Can you hear me okay?
Yes, we can. Thank you. Please go ahead, and we have about 6 minutes left.
I'm Judge Micah Pence. I'm a family court judge in Kentucky. We passed the presumption of equal parenting time in 2018. And I will say that this is a law that I was very worried about. I was very hesitant. It's probably not something that I would have supported. But in practice, I've been able to see some amazing things occur in my courtroom. When you have two great parents, they should at least have the same starting line. Before the presumption of equal parenting, what we had in Kentucky was an assumption that every other weekend and one night a week is what one parent should have. And that assumption meant that we kind of had a zero-sum game going. There was no reason not to come to court and fight if you're a parent who loves your kids and wants more than 6 days a month. Now that equal parenting is the presumption, what we're finding is that it's given society a different view of what's best for a child, that it's best for a child to have two parents in their life as much as possible. Even if it's not equal, then the time with a parent is preferred over a time with a third party, such as a babysitter or other care provider. We're truly focusing on building those bonds with a parent. And I've seen my caseload decrease because I see more agreements between parents when we're not focused on trying to prove why the other parent is a bad parent, and instead focusing on those best interest factors that have always been at the heart of our custody laws in Kentucky. I'm not going to tell you what to do in South Dakota. I just want to give you the perspective of how things have gone here. I have seen it be less adversarial in court. I have seen temporary orders that I can put in place to see whether or not equal parenting is going to work for this family, and then come back and be able to make an informed decision. I still have the same amount of discretion that I always have, but I believe that it makes the power struggle that is often between two parents lessen when the power is equal. So we don't see as much fighting and as much, I guess, hurt feelings as we normally would when they're still having access to their child. But I want to make clear in Kentucky, this does not apply to cases with domestic violence. This is the 75% of cases that does not include domestic violence. We have put other safeguards in place. For example, in my courtroom, I always have a victim's advocate available for domestic violence cases to help inform a domestic violence victim of their options and how this law does not apply to them, as well as access to our legal aid for those domestic violence victims. I know that that's often something that's discussed, but we've put those safeguards in place to make sure that our domestic violence victims are still protected. Thank you for your time.
Thank you very much. Then we also have online Deborah Hughes, and we have 3 minutes left. Ms. Hughes, can you hear us okay? Deborah Hughes? Do you find her on there?
She's on there, but she's not in the room, so.
Okay, so then she's not in the room, so we're going to go on to Whitney Reed. Ms. Reed, can you hear us okay? Okay, she's not in the room either, I guess. So then I go down, to Ms. Johnson, and we have a couple of minutes left. Ms. Johnson, Emma Johnson? Your microphone's muted, ma'am.
Oh, hi.
There you go.
Thank you for hi. Thank you so much for this opportunity. I'm fully in support of this bill. My name is Emma Johnson, and I am founder of Moms for Equal Parenting. And for the last 15 years, I have had the privilege and luxury of communicating with families all around, not only the United States, but around the world. And I can tell you in that period of time, equal parenting has become the norm. It has become the norm for younger parents, much younger than me. The world has changed dramatically. Laws are passing around the country that is making this the norm. Celebrities are doing equal parenting, and now this is the norm. And simultaneously, because there are so many data points of parents that are doing an equal parenting schedule, we have robust science that shows how great this is, not just for kids, as the other people that testified, they talked about how great it was for children, but I'll just take this moment to talk about how great this is actually for moms and women and gender equality. We see in communities where equal parenting is the norm, domestic violence rates go down. Child abuse rates go down. In Ohio, there's an incredible study that shows in communities where equal parenting is the presumption, there are lower reported and substantiated rates of child abuse. And the researchers concluded that it's because the moms are less overwhelmed. And it makes sense. I'm a mom of 2 teenagers. I get it. When I have not felt like I had support from my co-parent, my temper was a lot shorter. And I think other parents in the room can also identify with that. We also see, and I've actually been involved in some research that we've seen that moms that have equal parenting earn more. Communities in Europe that have equal parenting presumptions, there's more gender equality. This is the future. This is just happening whether you pass the law and support and perpetuate it or not. And we see it again in Kentucky, which is an incredible leader in this space, dads do spend more time with their kids in Kentucky after the law has been passed. We know, I need to tell you intuitively, you know the research, the more dads are involved with their kids, the better everybody is. So thank you so much for considering this bill. I'm hopeful that that your state will be part of the future that is supporting and promoting equal parenting for separated families.
Thank you much for your testimony. That concludes the 12 minutes. At this time, we'll take opponents to House Bill 1067. Any opponents? Ms. McCauley. And you'll let us know your order as well, please.
Good morning, Mr. Chair and committee members. Melissa McCauley, registered lobbyist for South Dakota Network Against Family Violence and Sexual Assault. It's a 72-member organization that serves 66 counties in this entire state of South Dakota. When survivors of domestic violence, stalking, coercive control, and child abuse finally make the decision to leave with their children, they are most immediately pulled into custody battles. Many do not have the financial resources to hire an attorney. When their abusive relationship ends, power and control does not stop. It often shows up as high conflict divorce and prolonged custody litigation. Even when there is a history of abuse, the parents who caused the harm can continue fighting for custody for years if they have the financial means to do so. The children are the ones that are getting caught in the middle. Let's make that very clear. People often ask why survivors stay. One of the biggest reasons is fear of losing custody and being forced to send their children to unsupervised to the person who has harmed their family. The fear is real. Custody evaluations can help determine best interest of the child, but they are expensive, they are out of reach for many families. The best interest of the child means that their concerns and their voices must be heard. The presumption of joint physical custody assumes that every child belongs in a shared parenting arrangement without first looking at the individual circumstances of that child. Children and teens tell their agencies that they're already being forced to visit offending parents, and they feel that no one is listening to them. Children need structure, stability, and safety. They cannot thrive if they do not feel safe. When their voices are ignored, they grow up to believe no one cares. Shared parenting already works when parents can set aside their differences and truly focus on what is best for the children. We are not against shared parenting, I want to make that very clear, when it is appropriate. But in high conflict and abusive situation, this bill makes it harder for an adult survivor to overcome a presumption that may not fit their family. The one-size approach does not work for every situation. We have heard from adult survivors who want to testify against this bill but are afraid of retaliation, including being dragged back into court to fight custody over again. That fear should tell us something. Please remember that this bill applies to all South Dakota families, including those that have been in harm's way. We cannot assume every parent is safe simply because we want shared parenting to work. Judges need the flexibility to do the full examination of every family situation without automatic presumption. Victims do not always feel safe reporting abuse. Even when their protections exist on paper, that does not mean survivors can safely access them. I also want to acknowledge that all of you should have received a letter from Zero V, which is a coalition in Kentucky that has been made aware of our hearings today. And as you can see on the last page, if you don't have it, I have extra copies of it. It says Zero V works closely with our counterparts in other states. The South Dakota Network Against Family Violence and Sexual Assault is the go-to organization in our state for information and advice regarding domestic abuse, and I strongly urge you to consult the network as you consider the shared parenting legislation. With that, I urge you to oppose this bill.
Ms. McCauley, who do you have next?
Yep.
Please come forward. We have 8 minutes left. Good morning.
Good morning, Chairperson and members of the committee. My name is Shelby Bergeson. I am here testifying on behalf of my own self. I want to speak to you today from two perspectives: as a professional who has worked in the domestic violence field every day for the past 6.5 years, and as a mother to 3 daughters who has had to navigate the family court system after experiencing over a decade of abuse. From a survivor standpoint, I have personally navigated the legal processes surrounding child custody with my ex-husband, who received a suspended imposition after attempting to stab me in front of my child. I know what it feels like to sit in a courtroom and have your safety and your child's well-being debated. I know what it feels like to relive trauma to try to secure long-term safety for your family, and I know what it's like to work up to 5 different jobs during the year to try to afford legal representation. The legal system is overwhelming. It's emotionally exhausting and financially devastating. Sustaining prolonged custody litigation requires resources that many survivors, including myself, simply do not have. Abuse is about power and control. It does not always leave visible bruises or result in a criminal conviction. It often happens behind closed doors, making it difficult to prove in court. Many survivors never report abuse, not because it did not happen, but because fear, financial dependence, stigma, and instinct to protect their children keep them silent. Let me be very clear. The absence of conviction does not mean the absence of harm. Plea deals, suspended impositions, or dismissed charges do not erase the trauma experienced by a victim or a child. In my professional role, I work alongside mothers and fathers who have experienced domestic violence. I sit with parents navigating housing insecurity, childcare challenges, limited financial means, overwhelming legal costs, and particularly in our rural communities, limited immediate access to supportive services. For many survivors, the court system already feels intimidating and inaccessible. A statutory presumption of equal parenting time without careful consideration of the full context of abuse will create yet another barrier for victims who are seeking safety for their family. We must center the impact on children. Exposure to domestic violence, whether direct or through living in a coercive, fearful environment, is a well-documented adverse childhood experience. It increases the risks of long-term mental health challenges, substance abuse, and perpetuation of violence, not because survivors fail to protect their children, but because systems fail to recognize the full picture of abuse. I have seen this firsthand in my daughter, whose severe depressive episodes and suicidal ideation often coincide with visits to her father, as documented by her therapists and doctors. While this bill may benefit families where co-parenting is safe and cooperative, every family is unique. A broad presumption of equal parenting time risks unintentionally harming children in high conflict or abusive situations. Custody decisions must remain individualized, allowing judges to evaluate behavior patterns, power imbalances, and safety for both children and the protective parent. I ask you today to consider the children who are not in this room. They cannot testify. They cannot articulate what it feels like to live in fear, witness violence, or carry the anxiety of instability and conflict. They have no vote, no microphone, and no seat at this table, but they will live every day with the consequences of this decision. I respectfully urge you to oppose House Bill 1067 and ensure that safety, not presumption, remains at the center of custody determinations. Thank you for your time.
Thank you very much. We have about 5 minutes left. We have to go to Dr. Van Gilder Pierce. Online, please. We have about 5 minutes left, ma'am.
Thank you, Chair and members of the committee. My name is Dr. Taryn Van Gilder Pierce. I'm a licensed clinical psychologist in practice for the past 30 years with extensive work in the field of child custody evaluations. I am here in opposition of House Bill 1067. And what I can say is that shared parenting can be good for children. That has been met out in the research. However, it is in certain circumstances, such as people who voluntarily choose and are also able to co-parent amicably. Those conditions are the ones that set the precedence for the positive outcomes of that research. But it is not a simple equality of math or a math of time. Instead, we need to look at different cases where there is conflict or issues of abuse, as has been indicated, because children can be exposed to ongoing hostility, loyalty conflicts, and psychological stress. And so in those cases, that equal time structure can increase the child's exposure to conflict and reduce their emotional stability. So even though the presumption is a rebuttal, what we also know from the research is that it anchors the starting point differently. So instead of beginning with what does this child need, we begin with why not equal time, and that shifts things dramatically. The shift is not neutral. Also, again, parent conflict is a major risk factor for children, something that we need to protect them from, and it needs to be decided on each case individually. What we also know is that children developmentally are different, and so each case has to be considered based on a child's developmental and emotional needs. Moreover, I want to clarify that I am not an anti-father or anti-sexual orientation individual. In fact, in my early years in practice in Arkansas, I was fondly accused of recommending in favor of fathers. And fortunately, over the span of my career, when primary custody has been the recommendation, I have found that I, with equal determination, have recommended in favor of both mothers and fathers. So what I'm looking for here is not necessarily whether equal time is important, and one size does not fit all. So I request very clearly that you preserve the individual's child-centered best interest decision-making without the statutory presumption, because that is what is in the best interest of our children here in South Dakota. Thank you, and I'll stand by for any questions.
Thank you very much. Do we have anybody in the room that would like to? We have about 2 minutes left.
Can I talk? Good morning, Mr. Chair, members of the committee. I'm Steve Siegel. I'm the registered lobbyist for the South Dakota Trial Lawyers Association. I'll keep it brief since we're down to 2 minutes. We rise in opposition to House Bill 1067. We've seen this bill the last 10 years from Senator Pischke. It's essentially the same bill that we've seen for 10 years. It's died the last 9 years. My understanding from the Senate side, there's only 5 states in the union that have shared parenting. So it is rare, and I do acknowledge it may be shifting a little bit, but it's very rare. The problem that we have with this bill is it's make no mistake about it, ladies and gentlemen, it's an indictment on the circuit court judges in the state of South Dakota. We have excellent judges in this state. I see Craig and Jane Fifely sitting in here, John Song over in the Second Circuit, Sterling Honor graduate, Susan Sabers, #1 in her class. These justices, Pat Party up in Madison, in the National Guard for 36 years, these judges go to law school. They're trained in these things. They go to judge school. They see the demeanor of the witnesses. They listen to the testimony. They watch them interact in the courtroom when they're not on the stand. These people are suited to make these decisions. We don't need the legislature, with all due respect, to be telling them where to start in a family law case. And the biggest problem with this bill is it changes the focus from the best interest of the child to the best interest of mom and dad. Make no mistake about that. It changes the focus away from the child to the parents, and I think that's a bad idea, and for that reason, I ask you to please defeat it. Thank you.
30 seconds left. You don't have to run. We don't count that against the running.
Okay. Good morning, Mr. Chair, members of the committee. My name is Lindsay Ryder-Rapp. I'm a registered lobbyist for the South Dakota Advocacy Network of Women. I will just be brief and say the reality is that no child is the same, no fact pattern is the same. And frankly, I think it's appropriate for courts to have the discretion to determine what's in the best interest of the child. And I would just leave you with a quote from a recent South Dakota Supreme Court case in 2024, where the Supreme Court said, "Permeating our most typical custody and visitation decisions is the unremitting principle that our brightest beacon remains the best interest of the child in all judicial decisions concerning a child's care." And so we would ask this body to keep that intact and vote against this bill. Thank you.
Thank you very much. Representative, would you like to do a short rebuttal?
Thank you, Mr. Chair. Representative Bobby Andera, District 10. Well, we've heard about domestic violence, so on and so forth, and I just want to ensure that this bill does not mitigate any of that. in fact, it refers to 25-445.5, that the court shall consider a conviction of domestic abuse as defined, a conviction of assault against a person as defined, and a history of domestic abuse. So I just want to allay some concerns if that was something that any of you were, possibly concerned about. Overall, we talk about what is good for the child. So let's ask ourselves that question: what is good for the child? What does it feel like when a child, for some reason or another, can no longer see the father, or can no longer see the mother, or can no longer see the father's mother, i.e. their grandparents, their aunts, their extended family? This is very traumatic for many children out there. And if this presumption says, okay, in the cases where these are two good parents, safety is not a concern, why would we not pass this type of legislation? That is all I have to say, and I'll stand by for questions as well as the people who are online and in person. Thank you.
Thank you very much. We'll close testimony at this time. We're going to open it up to a short period of time of questions. Any members have questions? Representative Roby.
Thank you, Mr. Chair. I'm not sure who this question will be for, but I'll just ask it, and perhaps somebody could stand up and speak to it. So the representative just spoke, mentioned the situation where there's quote unquote two good parents. And so does anybody have data about, a situation where there's two good parents and kind of what typically plays out in that situation in terms of custody arrangements? I see somebody raising their hand.
I'd be willing to speak to that from a clinical experience perspective. I will say that through the years, I have been witness to individuals.
Excuse me, wait a minute. Excuse me,
parents.
stop. We need to
Yes.
identify yourself because nobody knows who's talking.
Sorry. Yes, this is Taryn Van Gilder Pierce. I'm a licensed clinical psychologist here in Yankton, South Dakota. And what I'm saying is that there is, what I've seen through the years are situations where parents have successfully emotionally separated and taken an aerial perspective in parenting their child. And in those circumstances where they choose shared parenting, it has worked wonderfully, especially in circumstances, for example, one where they had a children with developmental needs that required a significant amount of stability. And those parents harmoniously navigated shared parenting with that particular child. Also with normative children, I have seen that the parents, if amicable and able to navigate even difficult conversations with success, are able to parent and allow the child to have the qualities and assets that both parents can offer.
Thank you. And I will tell you, Representative, parties can enter into an agreement where they do that, and they've been doing it for decades. So there's nothing that prevents them from doing that at a time. Committee, Representative Hughes.
This could be for a proponent or an opponent. I'm just looking at our statute 25-4A-24, and the representative from Sioux Falls mentioned subsection 4 of that statute, which contains a reference to 25-4-45.5, which directs the court to consider in the request for joint physical custody whether just cause exists, and there's the use of a presumption, a rebuttable presumption, the same concept in the last sentence, well, the second to the last sentence of 25-4-45.5 states the conviction or history of domestic abuse creates a rebuttable presumption that awarding custody to the abusive parent is not in the best interests of the minor. So to try to, Mr. Chair, formulate a question, the court has already directed in a case involving domestic abuse to apply a rebuttable presumption against awarding custody to the abusive parent. So why is adding this rebuttable presumption so different in view of the judge's comments that this rebuttable presumption in favor of joint custody just means that both parents start at the same starting line. Mr. Chair.
Yes, go ahead.
Mr. Chair, so again, my name is Shelby Bergeson. I'm a survivor of domestic violence, and I also work at a domestic violence shelter. I'm the executive director there. I believe that something that's really difficult is, so in my situation, I had almost a decade of reported incidents with my ex-husband. A lot of those he got let go on plea deals. There was plea deals, there was suspended impositions, and so those are things that were taken into consideration when we looked at my custody arrangement, which is that he now gets custody time, shared parenting time with our children, which has in turn really affected their mental health. Often when he is with them, he is telling them directive things about me and telling them things about court cases, all things which obviously aren't good for their mental health. I will also say, as an executive director of a domestic violence center, there are more times than not when a survivor or victim of domestic violence does not make a police report, whether that is they are scared of the stigma that comes with it, whether they're worried they're going to be believed or viewed differently. We always offer to make police reports with victims when they come to our shelter, but a lot of times they are really scared about what that will look like moving forward. What's the court proceedings going to look like? Will they be believed? Maybe he said that he's going to say this about me, or she said she's going to say this about me, because it also happens to men as well. But I do think that when we talk about the convictions, that's where I personally have a problem with this, because it's very hard to get a conviction of domestic violence, and it can take years. My own court case took over a year and finally ended in a plea deal that resulted in a suspended impositions on the hopes that he would get mental help for his issues that he has regarding his own issues. But I would just say to please keep that in mind, that when you're looking at the history, there may not always be police reports, there may not always be convictions of domestic violence, just depending on what that situation looks like for each survivor, and each situation is going to be different.
Thank you. We have any further questions? Otherwise, we're going to move on. Okay, we're going to close questions, open up to committee discussion and or action. Okay.
Allow me?
Yes.
Thank you. My question can actually be to the pro or the opponents. We're striking out sections 2540A from 24 to 27, and particularly one of them is 25 that talks about a parental agreement for joint physical custody if both parents should agree on it. Why are we striking some of this out if we can agree upon this thing in the beginning?
Zach Martin here, Rapid City, South Dakota. Chair, committee members, thank you for the question, and thanks for a chance to say on this. And I'd like to give a couple brief statements.
Here to answer, you need to answer his question.
Yeah,
so
there's been a lot of anecdotal discussions about this, but I don't see there being a problem with there being that being in there. The case is that there needs to be a starting point that gives both parents equal access without there being one person having all the advantage over the other parent and using that to leverage them. And so having the opportunity where if both parents agree to shared parenting, they can already just do shared parenting, and they can do that with the court, and they can just go file their own paperwork and do it themselves very easily. This is to help out so when parents who don't agree and might use the kids as weapons, that the parent who's being attacked can actually have the opportunity to have access to their kids and be a parent, and the kids can have the love of both parents and spend time with both of them equally.
Representative Wahlberg, did I answer your question?
I think
Mr.
yes,
Martin.
that part is, we want to have that rebuttal presumption in there. So thank you.
Representative Whitman.
Are you looking for action at this time?
I am.
I would move 41st day.
We have a motion by Representative Whitman to move it to the 41st day. Do we have a second?
I'll second it.
Second by Representative Reimer. Further discussion?
Just really briefly, Mr. Chair, I appreciate the intent behind this proposal. I just have some concerns about creating a legal presumption that could limit our judicial flexibility and unintentionally impact some vulnerable families. So, yeah, thank you.
Thank you. So what we have in front of us is a motion to move this bill 1067 to the 41st day and act to provide a rebuttable presumption in favor of joint physical custody of a minor child by Representative Whitman, second by Representative Reimer. All those in favor will vote aye. Those opposed will vote nay. Mr. Secretary, please call the roll.
Representative Mortensen.
Aye.
Reich.
Aye.
Wahlberg.
No.
Roby.
Aye.
Fitzgerald.
Aye.
Reimer.
Aye.
Whitman.
Aye.
Massey.
Aye.
Cole.
Aye.
Poirier.
She had to,
Excused.
yes, she was
Hunt.
excused.
No.
Hughes.
No.
Stevens.
Aye.
9 yea, 3 nay, 1 excused.
House Bill 1067 will go to the 41st day. Next bill that we have up is House Bill 1305, an act to prohibit the dissemination of local information about a public officer and provide a penalty and civil cause of action therefore. Remind our sponsors we have 12 minutes for each side. Good morning, Representative.
Good morning, Mr. Chair, members of the committee. I am District 3 Representative Brandy Schaefbauer. And today I bring you House Bill 1305, and I have an amendment I would like to move, Mr. Chair.
Mr. Chair, I move 1305C.
C. Second.
All those in favor, vote say
Aye.
And I'd like to speak to the bill and the amendment, Mr. Chair. Thank you. House Bill 1305C is a bill to prevent the dissemination of personal information and addresses by our elected leaders, and to add these protections to our existing laws against doxing here in South Dakota. In this age of political warfare, doxing, or the public dissemination of personal addresses and information, it has become the favorite tool of the political left to expose elected leaders to political intimidation, harassment, and the constant threat of violent harm against elected leaders and their families. This is something I have experienced personally and on a near constant basis by opponents on the political left and even from Republican bloggers in this state. During the past 2 years, the former official SD GOP blogger published my home address in Aberdeen, as well as an address of my investment property out West River. This has produced a near constant obsession with my physical whereabouts on social media and an atmosphere that has frequently made me fear for my own personal safety and loss of peace of mind. We have a right to enjoy our personal properties with a level of peace and safety that ensures a reasonable quality of life, despite the choice to serve in public office. During my 2024 divorce, at a time when I was automatically covered by a mandatory spousal protection order, that same blogger published my home address in Aberdeen that only my immediate family and friends knew of. This specific instance constituted a violation of SDCL 22-19-1, the malicious and repeated harassment of someone covered by a protection order via written communication. Since that time, the same blogger has repeatedly posted my home address, including one article that was published just 4 days before the assassinations and attempted assassinations of Minnesota lawmakers and their spouses by a former Tim Walz staff member. It has been approximately 17 times that my home address or my whereabouts have been put out in the blogosphere. Legislative leadership responded to the Minnesota assassination by removing lawmakers' vital records from the LRC website. But this should be noted that my personal address was not on the website. So it was not the source of the leaked information. It was actually the voter rolls where my personal address was leaked to the public. As a repeated target of death threats and every sort of vile language by both mail and email, I immediately reported my situation and my concerns to House leadership, and nothing was done. This is why I am bringing this bill. While I remain a strong proponent of freedom of information and transparency by elected leaders and public servants, incidences of doxing, vandalism, home invasion, violent assault, and murder of public officials make it an unfortunate necessity to offer basic protections for public officials and political leaders whose voting decisions and political views are motivating factors for violent and unhinged people willing to use terrorism and harassment to achieve political aims. While public leaders understand and expect feedback, criticism, and sometimes even strong language from constituents, we should not be subjected to avenues of dissemination leading to digital gang stalking and the loss of peaceful enjoyment in our everyday lives. These lowbrow and criminal tactics should no longer be fair game to deploy against people who have volunteered to serve their constituents. 16 states so far have acted accordingly to limit the ability of violent extremists and unscrupulous actors to locate, intimidate, and even attack their political enemies. The amendment simply clarifies that immediate family members are also included in this bill and that doxing protections for elected officials expire 2 years after leaving office. Now, I just want to point out that this does not go to our law enforcement officers or judges. This is just elected officials. I'm asking you to do pass on 1305C, and I'll stand by for questions. Thank you.
Thank you very much. We have about 5.5 minutes left. Good morning, Representative.
Good morning, Mr. Chair, members of the committee, Representative Phil Jensen, District 33. Last year at Education Committee, I brought a bill that would defund the Huron School District to get them to the table so they could explain why they thought it was a good idea to have boys and girls bathrooms. I was doxxed by education lobbyist Rob Munson, and all my personal information was put out there on Facebook. Please support this bill. Thank you.
Thank you. We have about 6 minutes left. Anybody further? Good morning, Representative.
Good morning, chairs, members of the committee. I come to support this bill today, not necessarily because of me as an elected official. As many of you probably seen, I have been the subject of a few articles this last year, and I take all of them on the cheek and find actually most of them entertaining. But the reason I'm asking you to support this bill today is because last summer there was a series of articles talking about where does Representative Dylan Jordan live. I filled out all the proper paperwork. My address is public. My phone number is public. And during this article, they doxed my 80-year-old grandparents, my uncle, and my dad's ex-wife. I do not feel that my dad's ex-wife doesn't vote. My grandparents don't agree with everything I vote on naturally because we're all different human beings. Elected officials' families should not be doxxed because they disagree with how a representative votes. So please pass this bill. Thank you.
Thank you. Do you have any other proponents for House Bill 1305? Seeing none, then we'll open it up to opponents to House Bill 1305, and you have 12 minutes.
Thank you, Mr. Chair, members of the committee. My name is Tara Larson. I'm an attorney here in Pierre and registered lobbyist for the South Dakota Association of Criminal Defense Lawyers. And you've kind of heard a lot of my testimony before because a similar bill had come up, and so I'm going to do just a very brief refresher of everybody for everybody as to the First Amendment and what are considered true threats. But I do want to express my empathy to Representative Schaefbauer. You know, I do understand that there's been some nasty comments, you know, made towards her, and you know, it's not fair, but unfortunately nasty comments are not necessarily comments that are unconstitutional, right? So, or that aren't protected by the First Amendment. The First Amendment protects speech generally, what it doesn't protect are things called true threats. And we learned about this a couple of weeks ago, so again, I'll be brief. What is a true threat? Well, a true threat is something that theoretically disrupts society or foments violence. According to the Supreme Court, true threats include when a speaker directs a threat to a person or a group of persons with the intent to place the person in fear of serious bodily harm or death. Those are the magic words. From the 2022 Counterman versus Colorado U.S. Supreme Court case, I'm quoting, "Yet the First Amendment may still demand a subjective mental state requiring shielding some true threats from liability. This is because bans on speech have the potential to chill or deter speech outside their boundaries." Why is that? Well, because the risk, as the Counterman decision points out, and I'm quoting again, is a speaker's fear of mistaking whether a statement is a threat, fear of the legal system getting the judgment wrong, and fear of incurring legal costs, all may lead to a speaker swallowing his words that are in fact not true threats. This bill, even with the amendment, doesn't include any of the protections that could be considered constitutional. Now, knowing the case law and the background here, I want to go into this bill because it's a bit different than what we saw a couple weeks ago. This bill places the statute under Title 22-11, which are the obstruction statutes that actually, they have different definitions in them and more broad definitions, let's put it that way. Under the bill, you are prohibited from harassing a public official by putting their home, school address, or location. Location's important, that's going to be key. But you're prohibited from harassing them, right? Well, harassment is defined in 22-11. It's defined in 22-1132, and it says the term harass means knowing and willful course of conduct directed at any person which seriously alarms or annoys the person. And then there's a bit more, but to give you an idea. Additionally, public officer is defined in Title 22. And public officer is any person who holds a position in state government or any of its political subdivisions by an election or appointment for a definite period whose duties are fixed by law and who is invested with some sort of sovereign functions of government. Technically, that also covers non-exempt constitutional officers' employees, right? Because they're non-exempt, they're for a period of time. That includes them too. So let's do some examples of what would be a Class 6 felony under this rule. Someone posts a comment on a Facebook of somebody on the House floor making a stupid comment going, did they really just say that? Well, we posted their location, right? There's Class 6 felony. Same, let's go to an example of, frankly, even a spouse of somebody who happens to be a contracted non-exempt employee posts a picture of their husband doing something stupid on Facebook for the purpose of annoying them, for sure. Well, that could be theoretically Class 6 felony, right? Now, former employees, I do appreciate the fact that we have a 2-year look back, because I was going to use the Ted Clout example. But nothing prevents another person like Ted Clout from being elected and then subsequently being removed from office for doing the parade of terribles that they did, and then somebody posting on Facebook, I'm glad that person is rotting in prison, right? We just had an attorney general who accidentally killed somebody, and what if somebody points on Facebook and says, hey, this person just moved right next to me, just be aware. Well, again, Class 6 felony. Now, even the fear of safety language doesn't include the true threat language in it either. So, I mean, unfortunately, everything about this bill is kind of unconstitutional. And I would be remiss, finally, if I did not talk a little bit about the civil cause of action, because here's the thing. We always talk about prosecutorial discretion in this committee, and you guys go, okay, yep, there's prosecutorial discretion. All of the examples that you gave me, clearly a prosecutor would never do it. And I say, well, there's prosecutorial discretion until there's not, right? Well, with the civil cause of action, the prosecutor is the person who feels that they have been wronged. And I promise you there's no prosecutorial discretion in that. And if you look at it, it opens up to punitive damages without including the reckless, willful, and wanton, actual malice provision. It opens up to attorney's fees. It opens the attorney's fees alone. I guarantee you, as somebody who defends 1983 cases, you're going to find some, activist group that's willing to stand up and do a frivolous lawsuit to manufacture something so they can just get their attorney's fees on this. Again, while I have great empathy for the prime sponsor of this bill, this bill is a bridge too far. I ask you to vote no. I will stand by for questions.
Thank you. Do we have any other opponents to House Bill 1305 as amended? We have about 5 minutes left.
Good morning, Mr. Chairman, members of the committee. Justin Smith, attorney from Sioux Falls, the registered lobbyist for the South Dakota News Media Association. Like the previous speaker, I rise with definite sympathy and respect for the motives behind this bill. However, I represent all of your hometown weekly and daily newspapers across the state who need to be able to report on the public's business without fear of A, being charged with a Class 6 felony, and B, being subject to a private right of action that could expose them to punitive damages and which the public officer can bring without any regard to whether or not criminal charges have also been brought. This legislature routinely rejects bills that contain private rights of action. They're deemed to be something that is dangerous, especially for small businesses with no control over some of the standards that apply here. Our newspapers and news media need to be able to safely report on the news. Public notices, which newspapers are often required to put into the paper, delinquent tax notices, for example, they contain this kind of information. They're required to by statute. And if we put that information into the paper, it raises the question, just because someone is a public officer, if their address is put online or put in the newspaper, does it immediately, automatically create a reasonable fear of harm? What does public officer mean? Another bill that I testified in opposition to several weeks ago, 1084, did contain a detailed list of offices. This one doesn't. It could be, I'm assuming it's intended to apply to each and every single type of public office, from a township board all the way up to the governor of South Dakota. What does publicly disseminate? If you are talking to someone in the local coffee shop, does that count as public dissemination of the person's home or employment address? Publicly disseminate could mean everything from a blog to a Facebook post, all the way down to a conversation. What does the term immediate family mean? If you have a child who's 50 years old and you're serving in the legislature, does that still count as being part of your immediate family? The reasonable person standard is enshrined in our law all over the place, but page 1, line 14 of the bill, reasonably fear for the officer's safety. This just leaves our newspapers and their reporters in a constant guessing game where they're in constant fear or anxiety that they're going to be charged with criminal charges. And it's a Class 6 felony. So again, for all of these reasons, no disrespect for the motives behind this bill, and with all sympathy for the prime sponsor, because of the dangers and the uncertainties that it creates, the risks of aggressive criminal and civil liability, we'd please ask you to defeat this bill. Thank you.
Thank you. We have about 2 minutes left. Do we have any other opponents to House Bill 1305A as amended? Seeing none, then Representative, would you like to do a short rebuttal, please?
Yes, thank you, Mr. Chair. Representative Brandy Schaefbauer from District 3. First of all, thank you for considering this bill. We as elected officials at all levels of government, no matter if it's at the township level, the state level, or, more of our constitutional officers here in South Dakota. We do so because we love our state and we love the places we live. As I said in my opening testimony, we signed up for some of the harsh criticisms that this job brings. I don't think any of us are immune from that. But we did not sign up for the loss of peace of mind and enjoyment of our personal properties and location. If the wording is too low of a bar for reasonable safety in section 1, line 14, and then it continues to line 15, I would be open for an amendment to state reasonable fear of death or great bodily harm, as per our stalking statute 22-19A-1. And since this was brought up by Mr. Smith, I would be completely open to an amendment. News media can report on news. That's fine. That's their job, and we appreciate that. But I do understand, if you're delinquent on your taxes, but you probably aren't going to be here, are you? There is a bar that is set for us as public officials. Nasty comments are one thing. Like I said, we all get them. But stating personal whereabouts, personal home addresses, they do leave people in less, protected state of mind. There is mental distress. There is looking over your shoulder. There is fear of violence that you don't know exists when you purposely hide your address. So for that, I thank you for considering my bill, and I'll stand by for questions.
Thank you very much. We'll close testimony at this time, open it up to any questions. Yeah, Representative Wahlberg.
Question for the prime.
Mr. Chair, Brandy Schaefbauer, District 3.
Thank you for bringing this bill. You and I have talked about this a couple of times. We have another one that's coming up here that's very similar, and the only issue that I question is in section 2, lines 18 through 24, related to the civil penalties. Is that something that you're willing to get rid of?
Mr. Chair? Yes. There are civil penalties for stalking and harassment in our law already. So, I guess if you can't stop them from disseminating your information, maybe they'll be quiet when you place a civil action on them.
Further questions? And open up to then committee discussion and/or action. Representative Whitman.
I move 41st day.
Do we have a second? Second. The second by Representative Mortensen. Comments, Representative Whitman?
Just a brief comment. I'm one of the very few Democrats in our legislature, so I think it's clear that I'm not unfamiliar with feeling vulnerable in this area. But this is what I signed up for with public service. I believe it is public, and I believe that our constituents have the right to know who represents them, where we are, and how to reach us. And I don't necessarily view transparency as a threat. I think it's more of a cornerstone for our accountability. We already have laws that address threats, stalking, and harassment, and I can't agree with us creating yet another new felony tied to the dissemination of information. Thank you.
Any further discussion?
Mr. Chair.
Yes, Representative Hughes.
Well, I believe it's important always to examine any new legislative effort in light of what's already on the books. And public officer is already defined, and it does include virtually any elective or appointed office. And I do note that 22-19A-1 makes stalking the first offense is a Class 1 misdemeanor, the second or subsequent is a Class 6 felony. And it does extend to willfully, maliciously, and repeatedly following or harassing another person, making a credible threat to another person with intent to place that person in reasonable fear of death or great bodily injury, or willfully, maliciously, and repeatedly harassing another person by means of any verbal, electronic, digital, media, mechanical, telegraphic, or written communication, it just really looks to me like what we've been hearing from the prime sponsor is a Class 1 misdemeanor and with subsequent violations, a Class 6 felony based upon stalking. And so in my world, there's an existing criminal remedy for this, and I read the same stuff too, and I cringe, frankly, but I do on balance agree with the representative from Sioux Falls that moved to defer to the 41st day. So anyway, but I wanted people to know that we have these statutes that are criminal statutes on the books.
Any further discussion? Seeing none, that we have in front of you is a motion to move to the 41st day, House Bill 1305 as amended, an act to prohibit the dissemination of local information about a public officer and provide a penalty in civil case of cause of action. Therefore, all those in favor of the motion will vote aye. Those opposed, nay. Mr. Secretary, please call the roll.
Representative Mortensen.
Aye.
Reich.
Aye.
Wahlberg. Roby.
Aye.
Fitzgerald.
No.
Reimer.
Aye.
Whitman.
Aye.
Massey.
Aye.
Hull.
Aye.
Poyer.
Aye.
Hunt.
No.
Hughes.
Aye.
Stevens. 11 yea, 2 nay.
House Bill 1305A is amended. Go to the 41st day. The next bill we have up is House Bill 1298, an act to prohibit the electronic publication of certain information about a judicial officer or law enforcement officer and to provide a penalty therefor. Representative Roby.
Thank you, Mr. Chair. Members of the committee, Matt Roby, representative from District 5. I'm not sure if we're tired of talking about doxing yet or not, but here we are. So this bill was crafted after this committee dispatched a similar bill that was just dispatched earlier in the session, and really the attempt was made to try to find the right balance of matching matching the kind of the understanding of the committee that we were really concerned about judicial officers and law enforcement officers. So this only applies to judicial officers and law enforcement officers, and also adds that true threat language. And I just realized I forgot to ask the amendment to be moved. Yeah. Okay. Yes,
Chair.
Mr. Chair. Thank you, Mr. Chair. Essentially, what I was just speaking of pertained to the amendment bill as amended now, and I will stand by for additional proponents. Thanks.
Okay. We have about 10 minutes left on House Bill 1298 as amended.
Thank you, Mr. Chair and members of the committee. I am Katie Huruska with the Governor's Office. First, I want to thank this committee for their very, very deep and challenging questions on the previous doxing bill that I brought a few weeks ago, 1083. I heard all your concerns, considered each of them, and with prompting from some of the members and help from our prime, we now come before you with a new, much more narrow proposal. I don't believe there will be any opposition today, and I ask for your continued support of protecting our law enforcement and our judges. All across the country and in South Dakota, law enforcement officers and judges are being targeted, threatened, stalked, and doxxed. How we are engaging with each other and with our judicial system in this country and in this state is elevating the degree of dangerous threats and actual assaults against law enforcement officers and judges. In October of this past year, one of our federal district judges had said, quote, "Every judge right now is concerned about their safety and the safety of their families. The bench is facing never-before-seen levels of threats, which this judge called an attack on the rule of law itself. Protecting our law enforcement and our judges from threats and ensuring that they can carry out their duties without fear of harm to themselves and their families is a compelling interest of the highest order." This bill is now one section.
No one can electronically publish a home address, a date of birth, or social security number that in order to intentionally place that law enforcement officer or judge in fear of death or great bodily harm. So a few notes about what's changed. This bill is no longer inclusive of legislators or elected officials. This bill no longer adds doxing as a general crime for the general public. The crime is intentional, a little bit higher mens rea than knowing. The crime is now not perpetrated by intimidation, harassment, or causing emotional stress. It is just placing an officer in fear of death or great bodily harm. And then the information that would be posted is much more limited. We're not dealing with the biometrics and face and things like that. So thank you very much for taking another look at this bill and standing with our law enforcement and our judges. Thank you.
Thank you. Do we have any other proponents for House Bill 1298 as amended? 1298 as amended. Good morning, Ms. Ackerman.
Good morning, Chairman, Committee Member Stacey Ackerman, Executive Director for the South Dakota Sheriff's Association. You've got a busy agenda today. I provided you my full testimony on the previous bill held this year. We know that doxing has occurred with our partners in North Dakota, and we ask for your support on this bill. Thank you.
Thank you. Do we have any other? Good morning, Mr. Sadison.
Good morning, Mr. Chair, members of the committee. Greg Sadazan with the Unified Judicial System. We also support this bill as our work to improve security for judicial personnel has increased in our courthouses. It certainly leaves them more vulnerable in their home addresses and locations, and so we feel like this bill would help close that gap. Thank you.
About 5 minutes left. Good morning.
Good morning, Mr. Chair, members of the committee. Jenna Severin, South Dakota Police Chiefs Association. I too will be very brief, but we rise in support of House Bill 1298 as amended. For law enforcement officers, the risk of being doxxed can translate into serious professional and personal repercussions. Exposure of personal information not only endangers the safety of officers, but also jeopardizes their mental well-being and family security. Officers may experience increased anxiety, stress, and paranoia, which can diminish their effectiveness on the job and disturb their home lives. Our officers put themselves on the front lines 24/7, 7 days a week to serve and protect our communities from threats, violence, and bad actors of every nature. Passage of this legislation serves to protect them in return and sends a clear message that South Dakota appreciates the work they do and stands to support them and their families so that they can continue to effectively do their jobs and keep our communities safe. Please vote yes on this bill. Thank you.
Thank you very much. Do we have any other proponents? Good morning.
Good morning, Mr. Chair, members of the committee. Stephen Gamer here on behalf of the South Dakota Attorney General's Office. We too rise in support of HB 1298 as amended. We appreciate the support, the additional protections this bill will give to law enforcement officers and their families, and would urge its passage. Thank you.
Thank you. We have about 6 minutes left. Any other proponents for House Bill 1298 as amended? Seeing none, then I'll close proponent. Ask if there's any opponents. Seeing none, then we don't need a rebuttal. At this time, open up any committee questions. Any committee questions? Seeing none, then we're going to open it up to committee discussion and or action.
Mr. Chair.
Representative Wahlberg.
Motion to pass.
Second.
We have a motion to pass by Representative Wahlberg, second by Representative Fitzgerald. Any comments?
No, sir.
Representative Fitzgerald? No, sir. Okay. Then what we have in front of us is a do pass motion on House Bill 1298 as amended, an act to prohibit the electronic publication of certain information about a judicial officer, law enforcement officer, and to provide a penalty therefore. All those in favor will vote aye. Those opposed, nay. Mr. Secretary, will you please call the roll?
Representative Mortensen.
Aye.
Reich.
Aye.
Wahlberg.
Aye.
Roby.
Aye.
Fitzgerald.
Aye.
Reimer.
Aye.
Whitman.
Aye.
Massey.
Aye.
Call.
Aye.
Poirier.
Aye.
Hunt.
Aye.
Hughes.
Aye.
Stevens.
Aye.
13 yeas, 0 nay.
House Bill 1298A, having received unanimous vote, is hereby passed. Any objections put it on consent? Seeing none, it'll go on consent. Our last bill for the day, then, is House Bill 1270, an act to provide an apprenticeship pathway to practice law in South Dakota. At this time, we'll take proponent testimony. Good morning, Representative Fitzgerald.
Good morning, Mr. Chair and members of our committee. I am Mary Fitzgerald, District 31, Lawrence County. House Bill 1270 is an act to provide an apprenticeship pathway to practice law in South Dakota. Is this a far-fetched notion? It's not. I have such a limited time, and this is such a complicated issue. I'll try to make it as quickly and as easily as I can. From 1903 to 1983, the South Dakota Law School had a diploma privilege program. You applied to law school, you graduated from law school. The day you graduated, you were sworn in to the state bar. But this bill, we'll go back to the bill now, is about creating an alternative pathway to licensure that recognizes real-world competence and mitigates the barriers posed by an exam that does not test on South Dakota law or practice. The current bar exam stands alone in the nation. There is a multiple choice and essay portion of the exam. It is the only bar exam that uses a non-compensatory scoring method, requiring applicants to pass every section independently. A high score on one portion cannot offset a lower score on another portion of the test, no matter how strong the overall performance is. This is a rigid structure, creates unnecessary barrier to licensure, and does not reflect the competency in the real world of legal practice. It's really the exam of nowhere. This has contributed to a shortage of licensed attorneys in this state, especially in rural areas, and has limited many South Dakotans access to affordable legal representation. So this one-of-a-kind bar exam has South Dakota at one of the lowest attorney per capita ratios in the nation, second only to Wyoming. Approximately 69% of the licensed attorneys are concentrated in just 3 counties, while 35 counties have fewer than 1 attorney per 1,000 residents. And there are 6 counties in the state of South Dakota that have no attorneys at all. We should be deeply concerned about the growing shortage of attorneys in our state. Our young people are leaving, and we are facing a great tsunami of retirement age lawyers. Without meaningful reform, South Dakota, especially those in rural communities, will lose access to justice, leaving families, businesses, and communities without the legal support that they need. Now, I've received several emails, and they break your heart if I could sit and read them all. But I got one Saturday night as I sat out in my house in Fort Pierre, and I'd like to read it to you, and I'll end with that. I'm a graduate of the University of South Dakota, earning the top grade in 3 courses. Despite a strong academic performance, a small number of multiple choice questions on the bar exam have kept me from licensure. Since graduating from USD Law, I have worked 7,000 hours in a state's attorney's office, served as a federal HR specialist, gaining extensive experience and a deep understanding of employment law, served and currently serving as a reserve police officer for 6.5 years, applying principles from law school in real-world police work and investigation. I've taught at the university level law-related courses. I've served as an elected city council official. Yet I am not eligible for the current apprenticeship program. Apprenticeships work. They measure real-life competence over months of supervised practice, not performance on a handful of multiple-choice questions. Apprentices develop drafting, legal analysis, client communication, and courtroom skills, trials, hearings, and arguments. A bar exam cannot measure that. Mentorship transfers institutional knowledge and strengthens the profession. Extending this pathway to South Dakota Law School graduates creates a practice-ready, rule-ready attorney and helps solve the state's legal deserts. Attorneys routinely instruct jurors to use their common sense to consider the totality of the evidence and make sound, reasonable decisions. This is one of those moments today. I urge you to use your common sense and support House Bill 1270, and I'll stand by for questions. Thank you, Mr. Chair.
You bet. We have about 8 minutes left. Mr. Teason, you're up. We won't count the time that you're traveling against you, because you're one of those tsunami lawyers.
Mr. Chairman, members of the committee, my name is Dick Teason. I'm speaking for myself on this issue. I'm an attorney here in Pierre, where I practiced the legal profession since I graduated from USD Law School in 1979. I've been doing that for 47 years. South Dakota formally honored what was known as the diploma privilege, as you have heard by the speaker ahead of me. So, based upon that concept, if you were successful in law school, they graduated you. And under the diploma privilege, they believed that if you got through law school, you were probably capable of going out and practicing law. And they did that without the kind of program that's being suggested in this bill, where you would be working as an intern, basically, for some period of time. South Dakota formally had that diploma privilege for all the years that were described. It's incredible that we are still here managing our affairs with lawyers who never took a bar exam at all. But they did, and we were successful at that. So the question before you today is whether you should permit another path. I'm happy to say that I didn't have to take the bar exam. Frankly, I might not have been practicing law if I had to take the bar exam. I did real well in law school, but we didn't do multiple guess tests in law school. We were given a set of facts, and we were expected to know the law that we had learned during that semester, and we had one shot at the end of the year, or at the end of that semester, for each class to show whether we knew the law and whether we could apply the law to the facts that were given to us in that little blue book. We were expected to understand that every situation may have more than one answer. That's why you have two lawyers on each side in a case, because they don't agree that the facts, when applied to that particular law, is necessarily clear. That's why we have trials. So why then would we go down the road, which South Dakota has, of adopting a test, an examination that, frankly, in my view, under the multiple guess, is just that. It deceives you, intentionally, I believe, to choose the wrong answer. So there's a huge philosophical change in the way we taught you and in the way we decided whether you were capable to go out and practice law in this state. I think we made a mistake. I'm not being critical of the bar examiners. Please don't take my comments as that. This was being done nationwide. That doesn't mean that it's the right method, however. I still believe in my heart, even though I'm finally going to retire from practicing law, that there's more than one side to every story. And we need lawyers who learn the law and then apply that law to the facts. What we don't need is to continue on with an exam that I am convinced tries to trick you into choosing the wrong answer out of the four choices you're given. If you're not competent to practice law in South Dakota, then they should send you home and quit taking your money. But I don't think we should continue to train that person and put them into an environment where they get a shot at a test where one part of it is really structured and built by someone else, not from South Dakota, that develops questions that for which there really is more than one answer. Oftentimes, 3 of the 4 are good answers. So I hope you'll support this bill. This concept's been around a while. I think that mentoring is one of the best things we can do for young professionals, frankly, in every profession. And that's what this bill does. So I hope you'll support the bill and give our youth in South Dakota a fair opportunity to achieve licensure after they complete law school. If they don't have the oats, flunk them. Let them take that money and put it somewhere else. Thank you.
Okay, we have about 2 minutes left. Mr. Eastland?
Morning, thank you. Aaron Eastland, Rapid City. I'm a proponent of the bill. We've been kind of down this road before, and we're going to keep kicking the can down the road because we're not going to get it through the state bar or the judicial system to actually solve this problem. You just listen to people at the first bill that was presented today, and there's not enough attorneys. Why aren't there enough attorneys? Well, we have attorneys going through law school, and they're being shorted by not passing a test. My wife was one of those people. Every single person, there's 3 of my classmates sitting back here, and every judge here knows my wife and has had her in court because she is a victim witness specialist. She helped start truancy court in Rapid City. She was a divorce and custody mediator. She's currently the victim witness specialist for DCI, and it's a 2024 Civilian Employee of the Year. She can't practice law. She has to sit behind the rail because she couldn't pass 5 questions on a multiple choice test. Every single law student has the opportunity after their second year to go intern with a law firm or some other entity, and they're given permission to come and represent people in court. That's a second-year law student. Now we're denying that same thing to people that have actually taken all the courses and passed law school. We're really just cheating ourselves. We're really cheating ourselves, and it's time that something gets done. Because I've been here, this is my 3rd time, and there's no point in not getting people the representation that they need in the areas they need. I run my solo practice. I get calls every week of people that are on their 3rd, 4th, 5th, trying to find somebody to represent them. I'm too busy. This law firm's conflicted. We can't do it. I don't even advertise, and that's how many calls that come in. We need attorneys to help folks out. And if we don't, we're only hurting the state of South Dakota. Thank you.
Thank you. Our 12 minutes are up, but because of the fact we went so fast, I'm going to allow Mr. Barron to speak for 2 minutes and make it up to 14 minutes for each side. So, Mr. Barron, Professor Barron, you have 2 minutes, but I'm going to cut you off at 2. I've always wanted to cut off a professor before.
Thank you. My name is Roger Barron. I've taught as a law school setting as a law professor for 30 years, the last 25 of which were at USD in Vermillion. I taught 3 courses there. Because I have a background in education and educational principles and assessment, I've been asked at both schools that I teach by the deans to help other faculty learn about assessment. And so I want to briefly talk about assessment, because when you're wanting to make an assessment of a student's knowledge, there are 3 components that you look at. The first component is recognition. The second component is recall, and the third component is analysis. So in a very simple hypothetical, you might have a question that says, the capital of South Dakota is A, Sioux Falls, B, Pierre, C, Bismarck, and D, Rapid City. Now, most of us in this room could say, well, yeah, I know that Pierce is South Dakota capital, and we've heard that, so that's recognition. Recall takes it a step further. In the recall analysis, you might have a short answer question that says, what is the capital of Iowa? And the answer, of course, would be Des Moines, but the student would have to regurgitate that from learning, not recall not recognition, but recall. And then the third, more sophisticated, is analysis, critical thinking. And if I take this little scenario into an essay question, I would put forth that there is a mythical new state called New Caledonia. That's what they do with law school exams. They create a mythical state of New Caledonia. And you have been elected as a representative of New Caledonia. And you're charged with making a recommendation to the legislature as to what city should be the capital.
You got a little less than
Now we
30
have a-
seconds, Professor.
We have a city called Metropolis in the northwest corner. We have River City in the southeast corner, which is on a river, and then we have a city in the center called Centerton. Now, based on what you know, what city would you recommend be the capital? And what other questions would you like to pose before we make the decision? That's an analysis question best suited for an essay question. My time up?
You did really well. Yes, it is. Thank you.
I reserve rebuttal. I think Mary said I can have rebuttal.
Yeah, you might have used that up too. I'm just teasing, Professor. Do we have any opponents to House Bill 1270? And if you could then let me know, then your order of individuals as well. We'll give you the same amount of time. Thank you.
Thank you, Mr. Chair, members of the committee. Greg Satazon on behalf of the Chief Justice. I'm going to hit start on my 4-minute timer so I stay on time. Very respectfully, I would say this conversation should not be before this body. It should be before the Supreme Court, who is uniquely positioned to make decisions about the admission of lawyers and the bar exam, which is recognized in Article 5, Section 12 of our Constitution. The goal of bar admission is not to find what's in the best interest of the people that want to be admitted to the bar. It is what is in the best interest to serve the profession and to protect the public. While USD Law School does great work, I'm a graduate of theirs. I know many of the folks in this room as well. They do great work. Their role is not to regulate the admission to the practice of law. Speaking specifically to House Bill 1270, it is also not the role of a single lawyer to decide if a person should get their licensure or not, without any other objective criteria or third party to make an examination. And I have to hit on this because I think it's a reality. The numbers that I am very confident in is since 2014, there are 88 graduates of the University of South Dakota School of Law that have not gained licensure. And the regents issued a report in 2016 at their planning session to discuss concerns about the law school. And their finding, I think, is really important when you think about who regulates the profession and why the court has to hold that authority. In the past 10 years, USD has grown increasingly less selective about which applicants receive offers. USD has admitted less apt students to maintain tuition revenue. Of greatest concern is consequences of this 10-year trend. Using the risk scale, the majority of USD law students have been at high risk for failing the bar exam based on the median LSAT. To me, that's a strong statement from our regents about why the South Dakota Supreme Court needs to regulate the bar exam and not the University of South Dakota School of Law. Specifically to the bill, House Bill 1270, here's the flaws. There's no objective competence or character assessment associated with the licensure after that apprenticeship is completed by a third party. It's entirely in the hands of that lawyer. That lawyer can be handpicked. There's nothing in the bill that says it can't be a family member, a spouse, a close friend. There's no training, oversight, or supervision requirement for that lawyer. It's unlike any other apprenticeship program in the country. It does nothing, there's nothing in this bill that improves the geographic distributions of where our lawyers are located. And the need for more attorneys cannot outweigh the assurance that those that we put out there to protect people's lives, property, business interests are not measured for a degree of competence to make those important decisions. The Supreme Court is in that role. They have to assess what are the barriers to admission versus how do we ensure we have competent lawyers. That's a discussion that the court has consistently engaged in. Most recently, it's adopted the next generation bar exam for 2027, which is a new bar exam that's more skills-based in recognition of the fact that we do have to innovate. We can't just rest on our laurels that the current bar exam is perfect, and we do have to be critical and do that in a measured way, in a very thoughtful way. It was also mentioned that the Supreme Court recently adopted the public interest pathway. That pathway allows 10 law students in this 5-year pilot to complete curriculum at the law school, work with a supervising lawyer who monitors their performance, who has to provide and prove that competency, prepare a portfolio of work that is then reviewed by an independent board of bar examiners to assure that that training component was actually work related to the profession, not making copies, not answering the phone, practicing law and what that looks like. And so with that, Mr. Chair, we would ask that House Bill 1270 be sent to the 41st day. Thank you.
Thank you. Who do you have next?
Retired Judge Jane Fifely.
Morning, Judge.
Morning. I'm retired, can be Jane. Thank you, Mr. Chair and members of the committee. I appreciate the opportunity to be here. My name is Jane Webb Fifely. I've been on the Board of Bar Examiners since 2017. I'd like to address, on behalf of the board, two of the many issues that we have with House Bill 1270. The primary one is the lack of a character and fitness review for people who are seeking admission to the bar. A criminal background check is simply insufficient to gather all the information that the public needs to be protected from. And so just let me explain a little bit how it happens. If you apply to be admitted to the bar, you fill out under oath a very lengthy application. It tells us every place that you've worked, why you left there, whether you have debt that's in arrears, whether you haven't paid taxes, what lawsuits you've brought or have been brought against you, any resolution. It tells us about where you went to school, post-high school, if you had any issues while you were in in college or in graduate school. And also, we ask you to tell us about your criminal background, including your juvenile record. This information then is all collected. We send out, or the entity sends out reference checks. Those go to all the creditors that have been identified. It goes to law enforcement entities to determine if this information was accurate. It goes to jobs, to the employers. It goes to the educational institutions to find out what happened when you were there. And so we want to know, are we getting the same information from the applicant that we are getting from these reference checks? So the information comes back to the Board of Bar Examiners, and if there are any red flags, neglect of financial affairs, criminal activity, violation of court orders, failure to pay child support, perhaps you've had too much, you've been litigious, you've neglected your own financial affairs, you've demonstrated inability to follow court orders or to follow the law on a regular basis. So if it's something minor, these don't sound minor, granted, but if it's something minor, frequently we can work that out with the applicant. They can provide us more information. But if it is serious, we have a hearing, and that applicant has an ability to come before the board and explain by clear and convincing evidence that they have good moral character and are fit to practice law. A law license is a privilege. It isn't a right. The public has the right to expect that there are guardrails in place so that people who are admitted to practice law can do that appropriately when they're representing people in the most important affairs of their life. The second issue is we believe it's untenable to expect that one person, a supervisor, could make the decision that a person has the minimum competence to practice law, that they have good moral character, and also that they understand and can adequately apply the rules of professional responsibility. Without a character and fitness check, the supervisor might have an apprentice who graduated from USD, say in 2010, went to Iowa, got a law license there, practiced, and then was disbarred for some reason. Perhaps the supervisor knows they were disbarred, but they wouldn't know. Was it because of drug addiction? Was it because of financial malfeasance, failure to follow court orders? Was it criminal activity? So the supervisor unwittingly can have a person in their office who puts their reputation at risk and, more importantly, can harm the clients in that office. Also, the apprentice is at a terrible disadvantage. The power structure is very unequal. If the apprentice isn't being given appropriate supervision, if his apprentice is being asked to do something inappropriate, there is no remedy for the apprentice. But the bottom line for us is we think the bill is flawed, that it isn't designed to protect the public in any way, and moreover, it doesn't protect the apprentice, and it doesn't give the supervisor the tools, the mechanism to assure that the person is qualified to practice law. Thank you.
This time we'll have the online of Mr. Fulton. We have about 5-6 minutes left max.
Thank you, Mr. Chairman. Neil Fulton, Vermillion, South Dakota, appearing today on my own behalf. My opinions are my own and not that of my employer. A few objections to 1270. I've been engaged with bar examination as a practicing lawyer for almost 30 years, a bar examiner, and in the most recent years, a legal educator. This bill talks about numbers and bar exam statistics that no longer exist. For the state's law school, the pass rate of the bar exam in 22, 23, and 24 was 92, 91, and 92%. That is a very different set of circumstances, and in some part, that is because the issue that Mr. Sadazan raised about entering credentials discussed in that Board of Regents report has changed. The entering LSAT at every band that is tracked is 5 points higher at that point. We're in a very different world in terms of the students coming in the door at the law school and their performance on the bar on the back end. A second issue with the bill, Mr. Chairman, is that to the degree we are trying to get lawyers into South Dakota communities, the issue is not the bar exam, the issue is demographics. I would venture to guess that no lawyer in South Dakota talks to as many potential law students or lawyers as I do. If you look at the students who have matriculated to USD Law since 2019, 90 of them are from Sioux Falls, 103 are from the Sioux Falls Metro. If you look at where those students have gone to work, 126 have gone to Sioux Falls, 62 have gone to Rapid City, 48 have gone to Pierre, 23 to Mitchell, 17 to Yankton, 13 to Aberdeen, 11 to Watertown. There is nothing about those numbers that we can say about lawyers that we cannot also say about doctors, dentists, nurses, teachers. This is a demographic issue for us in South Dakota, and to the degree that we want to get lawyers into those rural communities, it is not to eliminate the independent oversight of bar admissions that exists with the Board of Bar Examiners and the court now, but it's to continue to invest in successful initiatives like Project Rural Practice, which has placed dozens of lawyers in rural communities, and the public service pathway that is discussed. The last thing I would say, Mr. Chairman, is it is important to me that any bar admission process be rigorous and reliable, that it protect the public and applicants, that it be independently validated and checked. I do not think that this system meets that, and I would ask the body to oppose the bill. Thank you, Mr. Chairman.
Thank you very much. We have about 3.5 minutes left. Is there a Rachel Norberg?
Yes, Mr. Chair.
Yes, please go ahead.
Thank you, Chairman Stevens, members of the Judiciary Committee. My name is Rochelle Norberg. I'm a solo practitioner in Burke, South Dakota. The testimony I'm going to provide you are comments to me individually, not that on behalf of the State Bar of South Dakota or any committees or sections I serve on. I'm asking you to oppose House Bill 1270 today. As previously mentioned by other opponent testifiers, there aren't any safeguards for the public or for the participant in this proposed licensure practice program. There's no guidelines, there's no framework for either the mentor or the supervising attorney to have to review and base against, nor is there framework or guidelines for a participant to review and be able to hold up their supervisor to. Without getting into some very technical language and specifics, House Bill 1270 allows a supervisor to rubber stamp a participant, either a yes or a no, for a professional license without checks, balance, oversight, or recourse. That's not good policy for participants, and it's not good policy for South Dakota. I'm a 2018 graduate of the University of South Dakota School of Law, and as I previously stated, I operate a solo practice in Burke, South Dakota, which is a population of 650 people. I'm a private practice attorney, but I also serve roles that are public in nature, such as a municipal attorney for several municipalities and chairperson of a board of mental illness for 6 counties in that area of the state as well. Outside of my day job, I serve several other community aspects, including extensive nonprofit work. I've had the ability to return to my hometown as a rural attorney recruitment program placement in Gregory County. That was an enormous amount of trust that was placed in me by my community at 25 years old. And that was placed in me both as a professional and in a personal capacity for work that I was anticipated to be able to do for my community based on my training and my experience.
Ms. Norberg, we have about one more person who'd like to testify. Can you kind of speed it up a little bit? I want to treat everybody the same.
Yes, Mr. Chair. The short of the story is House Bill 1270 doesn't protect the public. It doesn't protect the participant, and I would urge you to vote no.
Thank you. You got 30 seconds, and he wants to talk too, so that means you get 15 seconds. Did you say me too?
Good morning, Mr. Chair, members of the committee, Paul Kramer, State Bar. We oppose the bill for the reasons previously stated, and we respectfully request your no vote. Thank you.
Thank you.
Sam Madsen, South Dakota Trial Lawyers Association, me too.
Thank you for your consideration. At this time, we'll have a rebuttal. We'll give you 2 minutes on rebuttal. Thank you for driving all the way from Rapid City, by the way.
Thank you, and that's, quite frankly, that's something I wanted to bring up quickly. I handle cases everywhere in South Dakota, and I don't know another South Dakota attorney that doesn't do exactly the same. When you have 75% of South Dakota citizens that live along the I-29 corridor, that's where people are going to go. So what we heard here today are 0 facts. We heard a parade of horribles without support. They didn't address the diploma privilege in any reasonable fashion. Supreme Court justices here in South Dakota, lots of them have been through the diploma privilege. What we're doing is trying to find a pathway to success for people and make a change. It's clear that the State Bar, I sat on the committee on trying to change this through, and that was playing into a made hand, I guess you would say. We're just reverting back to the entrenched protectionism of the people that are in the bar that don't want to do something. Like I said earlier, every attorney learns more from the attorneys they practice with, whether that's at your internship or out in the field. We have all the tools we need. If there's a bad attorney, that's what the disciplinary board's for, and they've been quite successful in doing that. So I would, again, support the bill, and I would take any questions if there is any.
Well, thank you very much. We'll close testimony at this time. We'll open up for some short questions. Any questions by the Representative Fitzgerald?
Yes, I do. For Judge Fifley?
Thank you. Mr. Chair, I'm Janeway Fifley.
Thank you. My husband did an internship at the Public Defender's Office in Rapid City when he was in his 3rd year of law school. And he still talks about what he learned and how significant that training was in becoming a lawyer. My question to you would be, what is your response to the number of lawyers who have passed the bar exam but have been disciplined by the Supreme Court? I mean, in some of these infractions getting to November of 2025, where someone was nearly disbarred, but the Supreme Court told him or suggested or in their ruling that he find a mentor and learn how to be a lawyer. What is your comment about that? I thought that was interesting.
It is an interesting question. Thank you. That person was doing some things that clearly were inappropriate, and they were going to suspend him and allow him to try and learn to be better. But what's interesting about that is the day that that lawyer's off suspension, he could serve as a supervisor under this bill. And that is certainly something we don't want, someone that's been suspended and needs to be mentored to maintain his license being a supervisor.
Follow-ups? Yes. I believe the bill says they have to be a lawyer in good standing and been a lawyer for 7 years. That's in the bill.
Right. And so you are in good standing the minute you're off suspension.
My question to you would be, how do you protect people when people that have taken the bar exam are embezzling money, have substance abuse problems? How are you protecting the people if these people are getting through the program and passing the bar, but are not being good attorneys?
Well, if they have substance abuse issues, the Bar Association has a really robust program for that, provides a lot of supportive services for them. Those who are violating the canons of professional ethics, the rules of professional responsibility, those can be reported by other lawyers, and that's typically how it happens, that the bar has a real interest in ensuring those type of things don't happen, and that's why you do see the disciplinary board being very active.
Follow up, and then I will not, Mr. Chair, I will not ask another question. Yeah, from Judge Pfeiffer, from Judge Pfeiffer. But so that bar exam is no determination on what kind of a lawyer you will be or how honest of a lawyer you will be, really. Thank you.
Is that a question or a comment for me?
A question. Is that a measurement of how honest and how good of an attorney you will be, how good of an adversary you will be for your client?
Certainly the bar exam is a good measure of whether you have the ability to think on your feet, whether you have the ability to engage in logical decisions, whether you can take a fact pattern and spot the issues, whether you can identify all the various areas of law that are impacted. Absolutely. The multiple choice, the practical exam we have, the essays, the Indian law exam, and the test for professional responsibility. Absolutely. Those are all very, very critical. In terms of whether you are morally fit and appropriate to practice law, that comes about through the character and fitness, which is an extraordinarily important aspect of practicing law.
Thank you. Any further questions by the committee? Yes, Representative Poirier.
I have a question for Mr. Salzon.
I think he's French.
I'm really trying hard.
Greg Sadazon for the UJS.
Listening to the issues that you and others have with the bill, couldn't all of that be taken care of by a promulgation of rules if that was to state in this bill?
Mr. Chair, I think the Supreme Court certainly would have to essentially, I guess I should answer it this way. If there was support for the concept, there'd be a lot of work that would have to be done to create the rules, to create a process, just like there was for the Pathway program, which took 2+ years, input from all kinds of stakeholders. So I think the fact that you're asking the question means this bill has not touched on a lot of those different topics.
Yet we see a lot of bills that are like this bill. So what I'm trying to ask is, we do a lot of promulgation of rules whenever we want to start a new program. And so if we were just to put in promulgation of rules in the bill, then that you would have the flexibility to define your background investigation. You'd have the flexibility to define in more greater detail of what you want to see. And I'm asking, would that help fix your issues? Or will it help fix the concerns you have relating to this bill?
Mr. Chair, I guess I would start by saying I don't believe the bill can be fixed, first of all. The difference perhaps with the rulemaking that would be different is that as a separate branch of government, I think it would be unusual for the legislature to ask the Supreme Court to adopt rules to regulate the profession of law. And this is a little bit different, and I'll just acknowledge what the Constitution says, is that the Supreme Court shall have general superintending power over all courts and make rules of practice and procedures governing the administration of the courts. The Supreme Court by rule shall govern terms of court, admission to the bar, and discipline of the members. These rules may be changed by the legislature. So what I envision that this constitutional provision means is that the Supreme Court has that authority to regulate the profession. It would do so by adopting the rules that it feels are appropriate. The legislature may then, as it clearly says, change the rules. But what I don't believe it can do is the legislature create a program out of whole cloth that's not changed to an existing rule. So if this was a change to the current Pathways program, there should be some rules adopted that are in Code 1616A chapter that the legislature is specifically trying to change. That's just not what this is.
Very much. He's going to ask, and then you're going to ask. Okay.
Mr. Chair, question for Monsieur Sadazan. Thank you. Is the Supreme Court currently implementing, administering a program to allow for a public service pathway to bar admission?
Mr. Chair, Representative, yes, they are.
How does that, if at all, sort of dovetail into what this apprentice program could be if it were promulgated by the South Dakota Supreme Court?
Mr. Chair, so that program, and I didn't explain it in full detail with the limited time, but what that program is, it's focused on current law students. It specifically excludes people that had already passed because it has an entire component built into how the law school curriculum has to be developed for that path. And so if those individuals go through that process, which includes a 500-hour supervised practice program where that portfolio is built and vetted, the bar examiners can go in and watch how that person appears in court. They have to report their time in 15-minute increments as to what they're doing to qualify for that work. Then that can be approved, and they immediately are admitted to the bar upon graduation with the caveat they have to perform public service for the next 2 years. So it's just very different than what this proposes, if that's helpful.
Thank you.
Representative Cole.
Thank you. I really wish I spoke French right now because I'd ask it. But I don't, so you're safe.
Thank you.
Real simple question. How does the passage rate of our state compare to other states as far as bar exam success?
Mr. Chair, Representative Call, as of July 2025, South Dakota's passage rate made it the equivalent of 23rd in the country for successful passage out of 56 jurisdictions when you include the territory. So we're middle of the road. 23 out of 56 was our most recent.
Any further questions? Representative Hunt.
Hi, it's Mr. Sadazan. Whatever.
Close, you're good.
I do have a question. What do you believe that the evidence is that the bar exam actually shows a minimum competence for attorneys in our state?
Yep. Mr. Chair, as far as evidence, evidence makes it sound like it's 100% foolproof, which I would probably concede it's something that has to be developed. That's why we're moving to the next gen. But I think what it does is it creates a measurable, a very clear, concise standard that those applicants have to meet. And so I think having that and having it developed and having those questions vetted is really important, and it's just a piece of proving that. And so you have the multiple choice questions that test the skill set. You have the professional responsibility piece, you have the essay piece, and then you have that character and fitness. I think all those are components to really serve as a predictor of potential success. But is it 100%? I would say no. Probably no one would ever say that about an exam.
Okay, we're going to close questions and open up to committee discussion and/or action.
Mr. Chair,
Yes,
I move do pass.
we have a motion by Representative Hunt. Sorry. Do we have a second? Second by Poirier. Further discussion? Yes.
I'm a registered nurse, and we had to take the NCLEX before we could go practice in our field. And there are extensive evidence-based practice data and reviews that show that patient outcomes are highly improved after a nurse passes the NCLEX because they have better critical thinking skills. When I was doing research on this bill, there is not that same evidence that when you pass the bar exam, your minimum competence is reflected when you're practicing law. In fact, the Institute for Advancement of the American Legal System and The Ohio State University came together to conduct a study to evaluate the effectiveness of the bar exam. The overall finding was that the bar exam is not an effective measurement for minimum competence. Seeing that this is something that's being studied and proven that it's not effective, I congratulate the prime sponsor for bringing this, because South Dakota needs to be looking at other options and encourage more routes for practicing law in the state of South Dakota.
Further comments or discussion?
Mr. Chair.
Yes, Representative Mortensen.
I have a substitute motion to defer to the 41st day.
Second.
Okay, we have by Representative Mortensen, second by Representative Roby. Comments?
Yeah, this is an issue that's really been live throughout my tenure in the legislature. And I think that it is really to the credit of the law school and Dean Fulton, who we heard from today, as well as the Supreme Court, that there is a pathway, as Representative Hughes mentioned, that has been developed by the folks in the profession to provide more than one avenue for someone in law school to wind up getting a bar license. You know, I was doing a little bit of research as we were sitting here, and it wasn't always the case that someone who graduated from medical school had to take a professional licensing exam. It used to be that they had diploma privilege to just be a doctor if you went to medical school, like it was for my mother, who went to law school and then didn't have to take the bar exam. I mean, they used to have diploma privilege there as well. You know, I think about multiple choice exams and the derision thereof. I took that exam 10 years ago. It was very difficult. But, you know, there's a multiple choice component of the medical boards, of the nursing exam, of the accounting exam. And once I started going through all that, I realized how poorly situated this committee is to making these kinds of determinations. There is a unique provision in our Constitution, Article 5, Section 12. Usually the Constitution doesn't grant rulemaking authority, but it does in this case. I mean, the framers of our Constitution explicitly said it is the Supreme Court who should be the primary rulemaking body over questions like this, and that makes sense. I mean, if you put it into any other context or any other profession where this body said, we find flaw in your exam and we think you shouldn't have to take the exam, that you should be able to go this other way, and the profession all came in and said, no, we'd rather keep the process we have and keep making changes to it internally, I think that this body would almost uniformly respect and honor the wishes of that profession. We've made strides in this legislature on rural practice and gone about as far as the state can probably go to get people to be practicing law in rural areas. As someone who does practice in rural areas all the time, I would tell you, they're not just short on lawyers, they're short on doctors, they're short on accountants, they're short on teachers and law enforcement and on down the line. So I don't think it's this bar exam that is really the hindrance there. I applaud the Dean of the Law School. I think the Chief Justice has worked in good faith. They've been taking some of the pressure from Professor Baer and, frankly, from Representative Fitzgerald, who's done a lot of research and advocacy in this area. I think they've taken it seriously and they've started moving. They haven't moved as far as a lot of these folks would like, but I trust them, and I think we should continue to defer to them in this area.
Could I comment on?
Sure. We're going to do a brief, though, right?
Yeah, very brief. Do you notice that everyone that came up here today to testify against my bill is a lawyer? And the people that have motioned it to the 41st day and seconded it are lawyers?
Let's keep it towards the bill, okay?
Okay. We are elected by the people of the state of South Dakota to be their voice in the state legislature. If we refuse to listen to the people of our state, our people the regular average people in this state are going to have no voice in government. And I don't think we want that kind of government. I'm here to represent the people. I have listened to them, and I'm going to do my best for as long as I'm here to try to serve those people. Thank you.
Representative Hughes.
Well, here's my history. University of Nebraska College of Law in 1982. 211 students were admitted to my entering class. We graduated 160. 51 were culled out. I think over half those were flunked out. It's a different era, different time when academic rigors were actually rigors. We're in a different culture now. I'm not criticizing it. It's just, it's different. So then I go to work for a law firm in Omaha, which had 30, I think I was 39 or 40 out of the group. For 2 years, I was fair game to all the partners. I had a terrific mentorship, apprenticeship type program. I commend the sponsor. I'd love to see us have a real apprenticeship program. We have some awesome law firms in the state, some awesome lawyers that would be capable of apprenticeship. I also might be one of the only South Dakota Bar members. I'm sure I'm the only one in this room. I was sworn into the South Dakota Bar in Omaha in the Douglas County Courthouse by a judge who couldn't believe that he could administer the oath to become a member of the South Dakota Bar. But the reason was, in 1982, Judge Andrew Bogue struck down the residency requirement in South Dakota that a lawyer to practice here had to live here. So the senior partner asked me to take the bar exam. So I've spent 4 days, actually 5, because I had to come back to take the MPRE. I spent 5 days taking bar exams. I won't say I cursed maybe. I was so unhappy that I had to take bar exams. But I will tell you, having done that 2 years in a row, I don't begrudge the review that I had. It was a comprehensive 4 or 5 week long process of learning areas of law that I didn't study in law school. And the objective is to bring me to a level of competence so I can at least spot issues and know how to ask questions. There is a vast difference between the academic study of law, which you do in law school, and the actual practice of law. It's a whole different skill set. And so while I laud the effort behind this, this is something for the Supreme Court to do, and I hope they will do it. So thank you for listening.
Okay, what we have in front of us is a motion to move House Bill 1270 to the 41st day. It's an act to provide an apprenticeship pathway to practice law in South Dakota. All those in favor of the motion to move it to the 41st day by Representative Mortensen, second by Representative Roby, vote aye. Those opposed will vote nay. Mr. Secretary, please call the roll.
Representative Mortensen.
Aye.
Reich.
Aye.
Wahlberg.
Aye.
Roby.
Aye.
Fitzgerald.
No.
Reimer.
Aye.
Whitman.
Aye.
Massey.
Aye.
Cole.
Aye.
Poirier.
No.
Hunt.
No.
Hughes.
Aye.
Stevens.
Aye.
10 yea, 3 nay.
House Bill 1270 will go to the 41st day. We have a motion by Representative Wahlberg and second by Representative Cole to adjourn. All in favor, say aye. Aye. We are adjourned.
As South Dakota's public media network, SDPB serves everyone with transparency, integrity, and commitment to open access. Good, useful, and full of wonder. SDPB. SDPB helps shape South Dakota's future by educating, informing, and inspiring the next generation of thinkers, leaders, and creators. SDPB. Good, useful, and full of wonder.